Hey, good morning, everybody, and welcome to episode 8.
Eight.
Episode 8 of Coffee, Compliance, and Chuckleheads. As always, thank you so much for taking time out of your busy schedule to join in with myself and my two outstanding, brilliant, and charming colleagues, Eric Rubenstein and Jordan Johnson. Good morning, guys. How are you?
It's a good morning.
Good morning, it is.
And Jordan, I know you're out there in the southwestern part of the United States in Sedona, Arizona.
We're desert bound this morning. We're actually coming from Monument Valley, so I don't know if anybody can see. It's like way out in there in the. It's listen. There's nothing here, guys. I feel like I'm the only person, so this is good. Isolation is a good thing, I guess.
I'm just surprised that you have any level of internet at all.
Hey, I've got like foil antennas and stuff hanging over here, so no, it's good.
All right. So, as always, we want to say thank you for joining us. And today, I think we have an outstanding show for you because we're really going to focus in on two OIG specific aspects. One, which is the misperceptions and the fallacies surrounding exclusion screening. Second, we want to talk about the routine waiver of copays and/or deductibles and its impact on the potentiality for violating certain statutes and laws. And then finally, we want to get into talking about the Kaiser Permanente issue, I guess we'll call it, where the DOJ has intervened in what appears to be 6 different relayer cases. And this is really going to be a fascinating case. And I know Eric has been all over this. But before we get started, we always want to share with you what's in our cup of coffee each and every single morning. Again, want to say thank you to our sponsor, Invader Coffee. Guys, thank you so much for the bags of coffee, the swag, and all the good stuff. This morning, I have my whiskey barrel blend because it's still early in the morning and I need something to keep me calm, but something to pick me up. So that's what I got going on this morning. Jordan, what you got going on?
Whatever. So we're here where we are is it's the Navajo Nation tribe. So they have a little coffee place down here, and I haven't gone yet, but that's where I'm headed after this. So we're gonna see what they have, and they just said be careful with it. So whatever that means, I'm gonna be careful with it.
It's probably the peyote blend, so be really careful out there. And Eric, I saved you for last because I'm absolutely fascinated and blown away with the coffee that you're drinking and the story that goes along with it. So let me turn it over to you, buddy.
Yeah, so this morning I'm drinking some coffee that's with a charity that myself and my significant other, Jean Marie Laurie, are involved in. It's a charity called $4, and they've come up with a blend that you can buy for $18. 100% of the money is going towards $4. $4 is a really amazing charity. Their goal is to help get rid of outstanding bills for the uninsured and the underinsured, mostly through helping people with navigating charity care. There are a lot of people out there that are eligible for charity care and don't know about it. Hospitals are oftentimes not very open about trying to work with patients in getting charity care, or they make the process very difficult to navigate through a web of document requests and things of the like. And the example I was giving to Sean and Jordan is that there was one person that was helped recently by $4 where the hospital required that all of the documents in support of applying for charity care were to be faxed to the hospital. These are people that don't have any money to begin with. So the likelihood of them having a fax machine is low. And even in today's technology, I think we're all pretty technologically savvy, and I don't have a fax machine. If I had to fax something, I'm not sure how I would do it. I don't even have a landline in my house, so I couldn't even do a soft fax or an e-fax. I'd have to actually get a soft fax account in order to do it. So I really do strongly hope that you all go to $4, DOLLARFOR.org, and make a donation. It can be a small donation, it could be a larger donation, but it really is an amazing charity. Jean Marie sits on the board. I'm the whisperer to the organization with Jean Marie on trying to get some of the money into the program. They really do put a huge amount of the money that comes in to the charity. The director is a guy named Jared Walker, who's an amazing human being. And for about 4 years, he's been running $4 with almost no salary, living in what looks like his parents' basement, although he is married, so it may be his mother-in-law's basement or something. But it's a great coffee. It's a great charity. And it's good coffee. It really is good coffee.
No, man,
Good deal.
that's huge. That's awesome. And hopefully we see more of this, as things are going on and things are moving, we're seeing more and more, hopefully vendors, these large vendors getting involved, that have traditionally made, big margins, big profits, but really is trying to set up programs. This is a plaguing issue. And it's kind of like the issue that you put in the box and nobody talks about. Right. So it's awesome to see an organization, making strides and actually making an impact on that. That's awesome.
Yeah. And listen, for any of our viewers or listeners today out there, if you have a charity that is tied specifically to healthcare, we want to know about it. We'll reach out to the charity. They could reach out to us. We don't want anything in return, but we are happy to promote these charities that are doing their part to help ease the burden of medical bills and helping patients to receive treatments that they so desperately need for the problems that they're dealing with. So with that said, I also want to make everybody aware that we are happy to take any questions that you want to pose to us today. Our chat is live. Parvez Bashar, I see, and I hope I didn't massacre that. And if I did, I apologize because I am from South Georgia. But good morning, welcome, and let's get into our very first topic, because this one kind of this one doesn't irritate me, because I think there's enough confusion that has been put out there by the government that causes folks to maybe have a misunderstanding or a misperception of what the guidance actually is. So exclusion screening, it's something that every practice, irrespective of the size of your organization, should be doing. There's no ifs, ands, or buts about it, right? Whether you're a solo provider, whether you are, because even solo providers deal with vendors, and you are responsible for ensuring the vendors that you have engaging with your practice are not part of the OIG's LEIE exclusion list. But I have heard a lot of people, not just recently, but over the last few weeks and months, talking about the fact that you are required by law to conduct an exclusion screening of all employees, all vendors, every 30 days. That is a requirement by the Office of Inspector General. Eric Rubenstein, what say you, Mr. Former Special Agent of the OIG?
Well, first off, exclusion screening is a part of sort of your risk management and what we would probably call part of the model compliance. It is actually not a legal requirement to do so. It's a recommended requirement. You are actually not required by law to do exclusion screening, but understand that if you don't, you're at risk under the False Claims Act, and more importantly, you're at risk under the Civil Monetary Penalties Law for employing an excluded individual. So the first thing is that there's no legal obligation to do it, but by not doing it, you're putting yourself at risk by having an excluded person. Yeah. The guidance that comes out of the OIG is sort of in the ether, where they sort of leave it up to you as to what that cadence would be. You should be doing it at least yearly, is I think what the language actually says. But you got to keep in mind that if you're doing it at a cadence less than yearly, and the example I'll give is Soundex or Namedex, however you want to call it, where you're spelling a name inappropriately, and most of the screening tools don't have the ability to be intuitive to that. So if in January I run a check on myself and I spell my name incorrectly, and I don't do it for another year and I actually am excluded, then I don't show up for a year. And, for example, in January, if you've done it correct and you've gotten my name right, but let's say in February, I get adjudicated guilty in something. And as a result of being adjudicated guilty in something in February, you don't check me until the next January. We've gone 10 or, depending upon the time, 10 or 11 months where I've been in the wind. Particularly if you've spelled my name wrong one month, if you do it the next month and you spell my name right, you've caught it within that 30-day period. So it's really incumbent on you to do these checks on all of your employees across the board every month, because you don't want to be in a situation where you check me in January and then you didn't check me again until next January. And in the ensuing 11 months, I've gotten adjudicated guilty and the OIG has excluded me, and I've been excluded from Medicare, Medicaid participation. So getting that done on a monthly basis is really providing a really good risk mitigation and staying, ahead of the game to not run afoul. And the example that I give is that I had a case years ago with a large pharmacy chain where they had a pharmacy, it was a local pharmacy pharmacy from the national chain in New Jersey, where one of the pharmacists was Eastern European and had a very long name with a lot of letters, and they either transposed a letter or they did something, and the pharmacist was excluded and they didn't come up, and so it's a year later. And they come up and they now need to go and make good on that. And they had a year of billings going out onto this pharmacist in a pharmacy, part of one of the big box chains. So you can imagine it's hundreds of thousands of dollars, not including damages and, the 2-time multiplier for something that had they had just a little bit of foresight to do it every month, or even double check spelling of names other than Smith or Jones, they probably wouldn't have run into this situation.
I know, Sean, you're probably going to pick up some of the comments that are coming up through here. I imagine that's where you're fixing to go. And I think what's important as I'm reading those, I'm going to let Sean pick them up. But as I'm reading these coming through, it's important to note where the OIG doesn't, it's kind of gray, right? There are, and Sean will get into this now, there are specific, player or payers and plans that have requirements at a state level, at a local level, that have those requirements. So it's almost like a moving target. As a previous administrator, I'll tell you that we never did any of this. It's kind of out of sight, out of mind. We assumed compliance was doing it, but knowing what I know now, I would have engaged at like our monthly meetings with the entire hospital. This is something that I would have wanted to at least brought up so we know what's going on, because we just assumed all the doctors that were in our departments, everything was good, copacetic. So Sean, I'll turn that over because I know you're looking at these.
Yeah. So I love that we're having people engaging with us. Medicare Compliance One is posting some really great stuff, and I want to address some of those because they are right, and it's part of the conversation that Eric Jordan and I were having before we went live. So if you kind of see me veering off and looking off to the side, I'm not ignoring what's going on. There's a lot of comments that are coming in, and I want to make sure people don't think I'm looking at my phone or doing something other than fully engaging here. So a couple of things. First and foremost, there are certain states that do require you to perform an exclusion screen if you are participating with Medicaid. Now, you guys know as well as I do, just about every doctor these days is so frustrated with Medicaid. They're all opting out of it. So, but that's a different story tied to reimbursement and other problems. But yes, there are states that if you are going to participate with Medicaid, you are required to do an exclusion screen under state law. This is not a federal law. Under the federal law, it says you have to do your exclusion screens on a reasonable basis. Again, reasonable basis is subjective. Now, under the Affordable Care Act, okay, or what people refer to as ACA, under ACA, there are requirements that you have a corporate compliance program. Now, there is no, to Eric, your point, as we talked about before the show, there are only 7 recognized steps to a compliance program, right? And we know what the 7 recognized steps are. There is an unspoken 8th element, if you will, right? But it is not a mandated 8th element. They're starting to talk about the responsibility of an organization to conduct a risk assessment. So for me, part of a risk assessment would be the performance of your exclusion screening. Now, again, there is OIG guidance that does talk about the avoidance of civil monetary penalties, what they refer to as CMPs. Under the CMPs, they want you to take a more aggressive approach to your exclusion screening. And there is some language that, and I do know what what is being discussed by Medicare Compliance One, and thank you so much for your engagement in this. I think it's outstanding. The element of the risk assessment is something that every practice should be doing. Again, your policies that you create in your organization are going to dictate the frequency to what you're actually performing your exclusion screens. I know that there's been some revised elements. I know there was this whole conversation that took place between the Office of Inspector General, the Department of Justice, and HCCA at their roundtable meeting, and they talked about making the risk assessment a recognized element under the revisions that they were talking about doing. But again, if you look at the federal guidelines right now, it still says on a reasonable basis. I personally recommend to all of my clients, especially large medical practices, as well as to hospital systems, integrated delivery health systems, anyone that has a frequent onboarding of new employees, the engagement with vendors, transition of your staff. I think every 30 days would be extremely appropriate and responsible for the large group practices, hospital systems, and integrated delivery health systems. A lot of people ask me, where do you go to do this? Obviously, you could go to the Office of Inspector General's website, and you can do the LEIE exclusion list. It's a database. You have to download it. You go through it. It's not that hard to do, but it's extra work on top of what somebody already has as a workday. Second,
well, you can also do that live, Sean, and you can go right through their web portal without downloading it, and you can do a last name, first name check, and then there's an SSN verify. So if you actually have the SSN of the potential individual, you can do a verification that you're getting the right John Smith if you've got something that's a normal name. So you can do the database download, or you can do a live right through the portal.
Yep. There is also another organization out there that I absolutely have a tremendous amount of respect for. I think they do an outstanding job. The cost associated with doing this is minimal on a monthly basis. And it is called exclusionscreening.com. Again, it's exclusionscreening.com. They are based out of Washington, D.C. I think they do a fantastic job. I recommend them to all of my clients. I have no financial ties or affiliations with the organization. I get nothing by telling our viewers and listeners who they are. Again, I feel like it's my responsibility and the guy's responsibility that if we know there's a vendor out there that offers a service to help maintain your compliance and they do a great job of it, I want to make sure that we're introducing them to you all. So with that said, and I apologize, everybody, there are some messages that are being posted out there. Apparently, my granddaughters, Hadley and Finley, have decided that they wanted to join in, and they are posting messages to let everybody know that they are my grandchildren. So again, you never know what you're going to get.
Right. We start. Listen, we believe in starting people early in compliance, and so they understand. So we appreciate them being here.
Yeah, I was going to say, do they fall in the compliance or the chucklehead category?
They are definitely chuckleheads right now. They are 10 years old and 6 years old, and Papa's heart is kind of going a little fast right now. But I think it's absolutely wonderful. Girls, I know you're watching. I love you. Papa loves you. Now stop posting messages, okay? Okay. So that's everything that I wanted to talk about exclusion screening at this point right now. Let's move on to the next topic, which I think has equal importance, and that is the routine waiver of copays and/or deductibles. I have a lot of clients over the years that have, said to me, look, here's the deal, Sean. It's my practice. I have the right to charge what I want to charge to the patients. If I want to collect a copay or a deductible, that's up to me. And let me just stop right there and say, no, it's not up to you, because you've entered into participation agreements, not only with federal payers, Medicare, Medicaid, Champus, the VA, TRICARE. You have also entered into participation agreements with commercial payers, Blue Cross, United, Aetna, Cigna. So not only do you have a legal obligation to make a reasonable attempt to collect copays and/or deductibles from your patients, you have a contractual obligation to do so as well. And Eric, you and I and Jordan were talking prior to getting started about, the implications of potentially violating the anti-kickback statute, potentially violating the False Claims Act. But there has also been guidance. And again, we talk about this because we have a lot of connections to different people, all three of us do, within CMS, within different government agencies over our years. We both have received verbal guidance from both Region 1 and Region 2 that, and I'm going to stop. I want you to kind of explain it, please.
Yeah. So I think first, when we're talking about kickbacks, I think what we're trying to parse out is cash or in kind remuneration, sort of a straight deal. We're not talking about some of these nuanced agreements, joint ventures, things of that sort, where oftentimes the OIG will provide an advisory opinion. We're really talking about waivers of copays that are going from the provider to the patient. We're not talking about a kickback paid by a doctor to refer patients to another doctor or an MRI center. We're talking about the waiver of copays to patients and the effects of that. We're talking about things like in the Medicare Part D space, we're talking about the use of copay and coupons. I do a lot of work in that space with whether or not the use of those coupons are allowed to be used or not. There's, as a related aside, there's currently a case going on right now in Southern District of New York where Pfizer is suing HHS, claiming that coupon assistance or copay assistance programs do not violate the anti-kickback statute and that they're actually intended to help a group. Pfizer just did its oral arguments, I think, a couple of weeks ago, waiting to hear what HHS's position is going to be. If in fact the courts rule in favor of Pfizer, it's going to have a huge effect on the pharmaceutical industry with respect to the use of copay programs. And I surmise that if it's not a ruling in the government's favor, there's going to be an appeal. This is not going to be resolved. But generally speaking, when we get to the issue of waiver of copays, we're talking about the patient who doesn't have secondary insurance. They go to the doctor, and the fee schedule is, the reimbursement rate is 80% of the fee schedule, with the exception of some specific things like laboratory services are paid at 100% of the fee schedule, or certain types of diagnostic services that are covered 100%, vaccinations, things of that sort, certain screenings. But generally, we're talking about the provider renders a service to the patient. The fee schedule is $100. Medicare pays $80, the patient's on the hook for the 20, and the provider just waives that $20. Now, from the perspective of what I had been told by CMS and people at Region 2, that if CMS is aware of that, they will instruct the MACs to reduce the reimbursement to give you 80% of the 80%. So instead of getting $80, you'd only get $60 because you're already contemplating that $20 difference that's already in there. From an anti-kickback violation perspective, obviously the problem is that patients who are giving the inducement are going to continue to come back for services. So the example I always like to give is, in my career, I spent a lot of time doing a lot of podiatry fraud cases, and I could go on for days on podiatry fraud. I think I did probably 12 or 13 criminal podiatry fraud cases and a number of civil cases. I had trials involving podiatry fraud. And, I remember having one case where the podiatrist would go, multiple cases where the fact pattern was the same, where the podiatrist would go to the community room of a senior citizen building, 20, 30 patients would come in, routine foot care, typically not covered by Medicare for a bunch of reasons. A podiatrist would bill Medicare for the amount and then accept that amount as the full billed amount, waive the copay. I would go interview patients, and patients would say to me, no, I never got a bill. Like, why would I pay for that? It was just a pedicure. There really wasn't a medical necessity. So the inducement to the patient is continuing for services. There's a whole other discussion about kickbacks between providers and the effect that has on overutilization and the clouding of judgment and things of that sort. The thing I think that people fail to think about when you're talking about provider to provider kickbacks is that the medical necessity of the service is not part of the metric, meaning that the service can be 100% medically necessary or it could be 100% medically unnecessary. It doesn't factor into the metric of the discussion.
Right.
It's the tainting of the claim through the kickback. But when we're talking about the waiver of a copay for a patient, that is the inducement. You're getting patients to come in and get more services because they're not having skin in the game. When the Medicare program was established in 1965, the copay piece was predicated on a couple of things. One, that patients were going to have skin in the game. Now, generally speaking, when we talk about waivers of copays and we talk about the payment of kickbacks and what have you, the federal statute, the anti-kickback statute, only covers government payers, particularly Medicare, Medicaid, and the like. It does not include commercial payers. Where commercial payers have come into play on the federal side is with something known as the Travel Act. The Travel Act has essentially allowed the U.S. Attorney's Office to prosecute an individual for a violation of state law in which interstate commerce would be put into effect. It's similar to the theory, in my opinion, on the federal statute involving child support enforcement. A lot of people don't know it, but HHS OIG is an agency. The OIG is responsible for a federal statute involving interstate child support enforcement, and it has to do with interstate commerce. And the Travel Act is essentially a way to do that. And so what prosecutors have been doing is using the Travel Act as an impetus to charge essentially what would have otherwise been a state violation of, say, an anti-runner statute or something like that to get somebody charged. And, one of the first cases where they did that in the U.S. was on charging people involved in a very large case that I had a little bit of participation in New Jersey called Biodiagnostic Labs. It was a very huge lab case in New Jersey. There were a couple of trials that ensued from it, but the Travel Act was used there. And if you read a lot of the anti-kickback statute press releases that come out now, a lot of them really do encompass the use of the Travel Act, because it had typically been that it was very difficult to federally prosecute someone for a violation on a commercial payer. And so you may have had the same exact pattern of behavior for someone that they were paying $50 for a kickback, whether it be a commercial or a government. Well, you're sitting there trying to explain that to a jury. How are you explaining to a jury that one thing is bad and one thing is not bad? You can say, well, it's bad because the government says it's bad, but that doesn't have great jury appeal. By bringing the Travel Act in, you're really bringing sort of that 360-degree view of what the alleged behavior is, kind of full circle. But, commercial payers all have something in their contract about a kickback payment or a waiver. You'll
That's
see
right.
it. PBMs have it in their contracts regularly. And whether it's a direct contract, a PBM, the pharmacy, or if the contract is through what they call a PSAO, there's typically language regarding not waiving copays. And if you're going to waive a copay or what they'll call a cost sharing, and it's really, co-insurance, whatever you want to call it, the requirements to do that are really very, very strict. You typically have to demonstrate some pretty broad financial hardship.
That's right.
Even in the Medicare
I was going to
side.
say, on the pharma end, I mean, they're very, very, very strict. And what a lot of people don't understand is pharma has put into place many, many programs to help patients pay those co-insurances and co-pays. So there's actually programs, again, to not bypass the payment, but to get those payments paid. And there's tons of programs out there. So I think that's what they were put in place for.
And
go ahead,
Sean,
Sean, sorry. I was going to say, one of the things that you see a lot is the use of these charitable organizations by a lot of the pharmaceutical companies. And what you'll see is Boston is really the flagship district, the out of District of Massachusetts. They're really the flagship district for doing a lot of the pharma cases that involve these charities, where you'll see the pharma companies get snagged on essentially funneling money to the charities, and the charities are supposed to be blind to that money, but they're really just essentially supporting. So, you see there's probably 7 or 8 pharmaceutical companies that are now under CIA's corporate integrity agreements. And then they went after a bunch of the so-called charitable organizations that facilitate it. I do, outside of my work for Advise, I do consulting for a company that has a data analytics tool that specifically is geared towards ensuring that when a government payer patient shows up at the pharmacy, that coupon from the manufacturer is rejected. There's a pretty high error rate that's out there because, as everybody knows, when you show up to the pharmacy with your Medicare Part D card, unlike traditional Medicare A and B, the card doesn't say Medicare Part D. It's got bins and PCNs that are reminiscent of the commercial payers. So unless you have a really robust tool in place, it's very difficult to necessarily get that through. And the company I work for has about a 10 or 15% share of adjudicating these, which means that 85% of the industry is using other companies or not using anything. And, we've been able to demonstrate that there are pharmaceutical companies out there that have either no tool or poor tools, because we do it for some of the large box chains that do it. So just getting back on point is that, the waiver of copays on the government side is generally a no-no. The waiver of deductibles is generally a no-no. You'd have to have some really strong legal opinions and build that into your compliance program as to what the steps are going to be to waive those copays, you get into some really nuanced things, like people who are dual eligibles, Medis, Medicare, Medicaid, people that are on, particularly now, through ACA and some other things, lists, low income subsidies, where they may not have a copay, or their copay may be $1 or $3. So, there's some really complicated nuances that go way beyond anything that I can even come close to understanding. But the general rule of thumb is, if it's a government program, you don't waive a copay.
That's right.
You don't waive a deductible. And if it's a commercial payer, it's really going to be a contracted related issue. And, said most of the contracts that I've seen in the commercial space do not allow for waivers of copays.
That's right.
Particularly if you're talking about, if you're Medicare and you have a secondary, your copay is going to be billed by that secondary. And part of that is your coordination of benefits. Part of that on the pharmacy is called true out of pocket, and the coordination of benefits. And there's this system, I know I'm rambling a little bit, but there's a system that CMS funds called the E1. And the E1 system is tied to pharmacy and Part A and Part B to an extent, but it's really intended for the patient who shows up, doesn't have their insurance card with them, or changes insurance. And it's a way for the pharmacy to check the database of Part D to identify who the primary and secondaries are for proper billing and coordination of payments and this and that. It's a CMS contract that's operated by a company called Relay Health, who does a nightly download of data. And sometimes that E1 system is used for nefarious purposes. We could have a whole discussion. Office of Inspector General, Office of Evaluation and Inspections did a whole study a couple of years ago on the misuse of the E1 system. It was used and may still be, was being used as a way of mining potential patients for sales and marketing. But there's a whole study that they did. But yeah, the whole kickback issue is, the skin in the game was part of the reason why it was put into this original law. And the reason that it was done that was because, unfortunately, when Medicare was created, fortunately or unfortunately, I should say, there was this very high regard, as we've always had, to healthcare providers. And so there was a belief, it's an honor system, right? And what we see on a daily basis is that providers fail to hold up their end of the honor system bargain when they engage in, frauds. Not necessarily a waste and abuse, because that's sometimes error and mistake and things like that.
That's right.
But
that's the difference between fraud versus erroneous.
Correct. And those that engage in actual fraud don't care about those things. But, at the end of the day, the whole American payer system is a pay and chase system. It's based upon the theory that healthcare providers are generally honest and good. And obviously, as time has gone on, the system is becoming inordinately complicated. Should it be a 99213? Should it be a 99214? What's the nuance of this and that? And so, the issue of the waiver of copays is partly for that skin in the game to sort of counter that belief that healthcare providers are generally going to be honest and accurate. The problem is that our system is so complicated that when a Medicare beneficiary gets their explanation of benefits, they don't understand it. And then particularly if they have a secondary insurance in which they never see a bill, they care even less.
That's right. Let me stop you for just a second. A couple of things that I wanted to unpack real quick, and then I want to move on to the last of our topics today, which is the Kaiser story. But one, Medi, that one is such a pain in the behind to so many people, right? Because Medicaid always on their EOBs comes back and says, you were paid more by the primary than we would have paid if we were primary, so we don't owe you anything as a secondary. And that's actually not true, right? Because they owe you the difference between the higher of the two allowables. So when Medicaid says they don't owe you anything, that's inaccurate. Number two, and Medicare Compliance One, again, great job. You beat me to it. I was hoping Eric was going to pause for a minute and take a sip of coffee, but you beat me to the punch. Yes, there are, just as with audits, okay, the commercial insurance companies, the private payers, they have gotten extremely aggressive in their audits. They've gotten extremely aggressive in forcing providers and hospitals and health systems to hold up, to Eric's point, their end of the bargain, their end of the contract. And there are multiple commercial insurance companies or private payers, however you like to refer to them, that have actually gone after hospitals and have sued them for breach of contract or for violation of the contract, whereby they failed to make a reasonable effort to collect copays and or deductibles. And especially, they're very aggressive in going after providers who are out of network, because the providers who are out of network are doing whatever they can to try to convince these patients to come to see them, because again, they're going to get paid a higher amount of money by being an out-of-network provider. So they're willing to say, I'm willing to write off your copay because I'm going to get, like for Medicare, it's 115% of the limiting charge or whatever it may be, for Aetna or Cigna or United or Anthem outside of, the participation agreement. So from my perspective, you got to. I've always, from all the cases that I've been involved with, I've always known that there are 3 times where somebody can reasonably write off a copay. One, after making a reasonable effort for collections, you are unable to collect it. You could write it off as a bad debt, right?
Bad debt.
Yeah. 2, if the cost of collecting exceeds the amount you are trying to collect, then you have a right as a disproportionate amount to write it off. Now, that doesn't mean you just always write off any copays that are $5. Put it onto the patient's account, and the next time the patient comes in, ask them to pay their copay. The third one that I've always been aware of when it comes to the waiver of copays and or deductibles is, Eric, what you were alluding to, which is under Title 18 of the Social Security Act, it's indigency, if I'm not mistaken. And if a person is indigent, now there's a difference between doing it, Jordan, and you could speak to this as a former hospital administrator. In the hospital, you have to do a DTI, right? A debt to income ratio. And there's a whole sliding scale because of the charity care that comes into play and all that kind of stuff. But in a physician's practice, it's not the same way. In a physician's practice, they could basically say to the beneficiary, is there anyone other than yourself who's responsible or liable for your medical expenses? And if the person says, no, it's me, and I can't afford to pay this, then they have the right under Title 18 to be able to waive that copay and or deductible. Now, the insurance company may disagree with the waiver of that copay or deductible. And that would be an argument between the beneficiary and the insurance company. But Jordan, can you speak to, the indigency care, please?
Yeah, and on the hospital side, I mean, our first goal is the patient signed up with Medicaid, right? So, and if they're not, then we go through the enrollment process of trying to get them enrolled. Now, if the circumstances still apply and we have to go to the charity care, there is a charity care application that has to go through, and it's a formal. I mean, it's formal and it's invasive, right? It's invasive. They want to know, tax statements. They want to know bank account. I mean, it's bank account information and things like that to make sure. Only because we have seen situations where they say they can't pay, find out that they have 4 or 5 homes. I mean, we've had those situations, but we go through that process and try to get them enrolled into the charity application, charity care programs. Then, to your point, if we still can't get that done, we do get to obviously a bad debt, which has been redefined of how we write that off, but we will write that off as bad debt. You got to go through the proper channels, a hospital, and also state mandated discounts for self-pay patients. Self-pay doesn't always obviously mean uninsured. Some people choose not to because they can bargain, you get a discount, but there's state mandated discounts. The problem with the state mandated discounts is we all would like to think that it's coming from the Medicare allowable, right? Well, it's coming from the charge master, which is already inflated. So a 50% discount doesn't mean 50% from the allowable. And that's been my frustration. And I've made a lot of not friends from that, just to say. So I will tell you this, when I was an administrator over the cancer service line, we would have these patients come in and I would give them the discount from the Medicare allowable, 33 1/3 for the state of Tennessee. I would give them from the Medicare allowable. And then the CFO gave a call and said, dude, what are you doing? Like, I mean, it makes logical sense to me. And of course, it's supposed to come off the charge master, right? But
Right.
and so I think that's the point of contention right now. But those are the proper channels. Again, private practice versus hospital. Hospital, much more bureaucratic and red tape to get somebody there.
Yep. All right. So
it's like saying you saved. It's like when you go shopping and you bought something on sale and you said, I saved money. Well, you still went shopping.
That's right. I try to explain that to my wife all the time, and she looks at me and she goes, but I got it on sale. I know, but you still spent money. I'm so cheap. I swear sometimes it just drives my wife crazy. But anyways, all right. So I think we've done a great job with the help of our viewers in talking about the exclusion screening, the importance of understanding the requirements under ACA, the requirements under state law, the fact that the federal guidelines indicate that it's on a reasonable basis. We're all in agreement that exclusion screening needs to be part of your compliance program. Depending on the size of your organization, and if you're trying to avoid civil monetary penalties, the more frequently you do your exclusion screenings, the less likely you are to potentially be hit with civil monetary penalties. I think we're all in agreement with that. Second, waiver of copays and or deductibles, very bad idea. It's a contractual violation. It's a potential violation of the statutes, of the laws, and of your participation agreements. And now, in the last 15 minutes that we have together, I want to talk about the Kaiser Permanente case, because Eric, you've been all over this thing. Jordan, you and I have been on a peripheral level with this thing and kind of reading into it. For me, I think it's absolutely fascinating because we're actually seeing a huge integrated delivery system pushing back against the government and saying, we're not going to enter into a settlement agreement with you on this one. But let me pause because, Eric, I think you had some incredible insight into this.
Yeah, insight backdrop, Eric. Catch everybody up for sure.
Yeah, it's really interesting because there are 6 relators in this case, and so everything that I'm talking about is in public. I haven't gone and looked. There's nothing that I don't know. I haven't gone into the government's repository, PACER, the court repository, to read any of the filings yet. I want to do that. But you've got 6 relators. Relator is the technical term for a whistleblower, someone who has what's called original source information, which means that they didn't get it from somewhere else. They have really firsthand inside knowledge. When I was an OIG agent, I worked a lot of these cases. They're called key TAMs, or these whistleblower cases. Whistleblowers are entitled to 15 to 25% of the recovered amount if the government intervenes. If the government does not intervene, the relator is entitled to as much as 30% if they go on their own and do it. So there was just one recently, largest relator whistleblower key TAM case in Middle District of Tennessee against a diabetic testing company. And the relator in that case got $28 million. It was a $160 million settlement. So there's a carrot and a stick for people to do it. But this case with Kaiser is really interesting. So you have 6 different people have all filed key TAMs. Now, what we don't know, and I'm going to go into PACER to try to find this, is were they 6 individual people who all got together and then went to the same law firm? Are they 6 law firms? Sometimes you find on a national level, you have people who have information and they just on their own go, and it could be 2, 3, 4, or in this case, 6 individual key TAMs all filed in the same place. And it just is by happenstance, but all 6 people have information. In this case, the issue at hand is that Kaiser Permanente is a Medicare Advantage plan out in California. It's very big. They're based in California, but they've got a very large footprint. And the allegation is that they were manipulating patients' diagnoses to make them appear sicker than they were, which puts them into a different risk category, which means that this monthly per patient, per member per month payment is higher than if they were healthy. So if you've got diabetes and you really don't have diabetes, but they say you do, you get a higher amount for the care of that patient. And I know when I was at the OIG, there was always this constant debate about whether in an HMO scenario, there's actually fraud, because you're paid per member per month. So you can bill for 100 things or you can bill for nothing. But when you start to get into this adjustment issue, where the patient who is otherwise healthy now goes from, say, a risk score of 0 to a risk score of 5, or however that's really done, that manipulation increases the bottom line of the payer, which in this case was Kaiser Permanente. What makes this even more interesting is not only are there 6 people that have filed these key TAMs, which means, number one, that a lawyer representing these people has vetted this, because they are on the front end of the bill until the back end. And typically a whistleblower attorney gets 40%. The going rate's about 40% of the recovered amount. And all of that is on the back end, right? So you're not, as a relator, you're not paying anything up front. It's 40% plus on a settlement. or on a victory, the defendant also has to pay reasonable legal fees. So the firm get reimbursed for all of the cost of the litigation, plus they get their 40%. But in this case, you've got 6 individual people who all had original source information. They worked for Kaiser. They all made the same allegation. But the thing that really got me, that I thought was super interesting, was the fact that at least one of the people was a data person.
I was just going to say that.
And was intrinsically involved. So I'm going to pause, because I think, from a data perspective, Jordan is the data guy in this group, and data tells you, data doesn't, it doesn't really lie. It's how you interpret it, right? Like I'll always say, you can have a politician who has a 90% approval rating, but someone's going to walk around saying he has a 10% disapproval rating. And so it's really on how you look at the data, right?
Half glass full.
And to Eric's point, I wanted to know, did these people know each other? And the data person was at the end. These people thought this was going on, and then the data person was the one to validate it, because essentially what this is it's pattern building. So we're looking at a subset of people, to what Eric's saying, to say, the risk coding, the way that works, it's a very straightforward. I say straightforward. No formula that comes from the government is straightforward, but it's a point-based system, and the way things. And again, it ratchets up pretty quick on what your rate is just by the tweak of codes here and there. The diagnosis codes and that thing, comorbidity codes, and this kind of thing. And before you know it, you're in a higher bracket. So did somebody with that data recognize that everybody that started out at a core base here somehow ended up there? And that's exactly what I was curious to know, Eric. That's a good point. And I want to review that some, because clearly there's some pattern or nuance going on there. My guess is it's a sector of the similar patients that start out one way and progress to something else.
Yeah, and to your point, Eric and Jordan, the data analyst who is one of the 6 relators in the case actually made the allegation that many, if not all, of these diagnoses were changed a year after the claim was filed. That's pretty nefarious. That's what was going on.
If that's truly what happened, that took some thought. Somebody had a calendar reminder somewhere to let them know. But exactly that thought went into that.
So if you've got somebody that's working in data, then somebody created an algorithm, that algorithm was going to hit on this date at 12 months and 15 days. You're going to change their diagnosis, because maybe the person didn't have diabetes year 1, but they have it in year 2. And through this algorithm, they're able to change that. And if that, this is a really huge allegation, right? Because for a very long time, OIG has been putting out, Office of Evaluation and Inspection and Office of Audit Services have been putting out reports for years on risk adjustment and things relating to people seeming to be sicker than they were. It's sort of in the vein of, in Medicare Advantage, that there was this term that was used. There was always the cherry picking and lemon dropping, right? So you're cherry picking the healthiest patients, and by bringing in the healthiest patients, you're really keeping your bottom line high, because you've got people paying in. And this goes for commercial payers as well. I'm 53 years old and I'm healthy, right? I don't take any medicine, nothing. So insurance companies love me, because I go for my once a year physical. It's a few $100 or whatever it is. Other than that, I'm not really an impact on the healthcare system. But yet, if you're someone like Sean, who's got some health considerations, you're potentially someone, you're costing, if you and I were in the same plan, we might be a balance, right? And so the cherry picking is, getting the healthiest patients only, and then finding the lemon drop is trying to find the patients that are the sickest, costing you the most, and finding reasons to get rid of them. But this is really going to have, it's going to be an interesting outcome. How much Kaiser is going to fight it, because they're saying that they're not doing this. 6 relators It's like, can everybody be wrong? Is it a misinterpretation? I mean, when I would work key TAMs, people that were the relators were typically former or soon to be former, or you'd always say disgruntled, but they have a lot of protections. And so you get these people that come in and they make a complaint. The complaint goes without any action. And then 6 months later, 3 months later, they're on a performance improvement plan. And 3 months later, they're fired. And then, they go and they'll file their key TAM. There was one law firm in New Jersey that was famous. They would file a key TAM and then they would put a wrongful termination based upon age discrimination. So they put in they'd put in some civil rights violation. And then when the government would get ready to decline the case, the relator would go and they would get the complaint dismissed for all but the discrimination action because it was already in federal court. And so, sometimes that happens, but 6 relators in a case is really sort of an interesting thing. I really am curious as to whether or not they were 6 that all went to one law firm, because then that would imply that they all sort of chatted with each other.
That's right.
I just did a podcast that I do, Retro Fraud, where I talked to a former coworker of mine, and she had a very large one with 2 relators, totally separate parts of the country, didn't know each other, separate law firms, nothing. And they both went and had the same exact allegation. And so that makes the case a little bit more interesting and obviously compelling, because now you've got 2 different people saying it. But the data part is going to be super interesting, because you've got someone who's sitting behind the desk whose job it has to do with either data analytics or something involving the manner in which these risk adjustment scores are being calculated.
And I want to be very, very clear to our viewers and listeners. We are conveying what we know to be nothing more than allegations at this point in the case. Yep. We are not passing judgment. We are not making any insinuations that there was nefarious behavior, that there was an intent to commit fraud. We are simply bringing to you what we believe is a really spectacular case at this point right now. And I think everybody in healthcare, in a hospital system, in a large physician group, in a in a large physician group, a hospital system, or an integrated delivery health system, should be paying attention to this, because this case, to use Eric's term, has a cornucopia of things going on, right? There's coding issues, there's data, analytic issues, there's all sorts of things that are going on in this case. Go ahead, Jordan.
This case could set a huge precedent, and I think to Eric's point, because it wasn't settled out and it now is public, my guess is they're going to try to move through this thing sooner than later. This is not going to be one that they want to drag out a year and a half from now. We're still going to be hearing about. So I think it will move quickly. It will be public, but everybody should keep an eye on this one.
Yeah, and we talked about this before. It's interesting that Kaiser doesn't, is not going the route of a settlement agreement, right? Because in a civil matter for a False Claims Act, False Claims Act case, there's no admission of liability. And, as we were talking about, either yesterday or today, Eric, pay it, enter the settlement agreement, move on and be done with it. But Kaiser's digging in here and they're saying, we didn't do this. So I think it's going to be really interesting in the weeks and months to come as to what the outcome of this case ultimately winds up being, because as well as I do, and there's a lot of attorneys that are listening to us today who engage in the defense or even in the plaintiff side of a QTAM case. Once the government digs their heels in and once they start spending money and using human assets, they're not going to just walk away from this thing.
Nope.
This thing's going to want to go. I agree. They may want to avoid being on a corporate integrity agreement for an extended period of time. That was from one of our viewers. I absolutely agree with that. But to be able to put this is not an admission of guilt. Kind of I think gives them that walkaway card. But we'll see what happens. All right, so we have come to the end of our hour. I know all of our viewers and listeners are heartbroken. They're saying, guys, give us more. I promise you, we are going to go back to the drawing board. There's lots more that is going on in the world of healthcare. I promise you that we're doing everything we can to bring you the most accurate, timely, and authoritative information and guidance that's available. I want to say thank you to each and every single one of our listeners. Thank you so much. We'll see you next week, and we will try to do better.